Welcome to this training on how we can work together to implement the CARE Act services. We appreciate all the work that's being done on the county level already to help get ready to provide the support. The goal of these trainings will be to help you feel prepared as you begin to implement the CARE Act. And we really want to be responsive to your needs. So please share those needs, TA requests with us. Upcoming trainings are going to be listed on the website, careact.org, and we'll be sending out registration links for these different trainings, but please communicate your needs to us. We are here to help support you. So thanks for viewing this training. Make a note of any questions you have, any clarifications, questions, or follow-up. So on this next slide, I'll introduce some of the individuals who are going to be sharing their knowledge with us. We have Carol Clancy with HMA, Laura Collins with HMA, and then Ann Hadrius with the Judicial Council of California. And they have all been getting to know the CARE Act on a deep level and are really excited to share this overview with you. So on the next slide, we'll see a preview of what we're going to be going over. So the first brief section is just an overview of the CARE Act, and we'll have a very high level look at all the processes involved in that. And then we'll do a little bit of a deeper dive on the different roles related to the CARE Act. And we will be having follow-up trainings on several of these roles, but just wanted to provide, again, that high level overview. And then going into the different steps of the CARE Act process for that last section. So on the next slide, we see the objectives of this training. So the goal of this training isn't for you to be, to have no questions. We should better be able to do these things. So distinguishing between the different roles, describing some of the processes involved in implementing the CARE Act, comparing the different pathways, and summarizing some recommended services. So we hope you'll have an increased ability and understand that you may not feel 100% confident, but that's the goal of all these TA and training sessions, is to increase your ability to and feel more confident. So with that introduction, I'm going to turn it over to Laura to start that overview of the CARE Act process.
Thanks, Patricia, for setting us up. Yes, we're very glad to be here with you to kick off our CARE Act training series. So yes, we will start with a very brief overview of the CARE Act, and we always like to begin with the why. So let's go to the next slide. So the why behind the CARE Act, first let's start with the fact that there are over 1.2 million adults with mental illness in our state, and that over half of these individuals with mental illness aren't getting care. So the CARE Act's goal is not only to help these folks access services upstream, meaning as a diversion to possible hospitalization, possible incarceration, or possible LPS conservatorship, but the crux of the CARE Act is really promoting overall access to care and services, access for a select set of vulnerable and complex individuals who also may be struggling with accessing other supports, including stable housing. Let's go to the next slide. So now that we're quickly grounded in the why, I'll briefly touch on the what. So what does the CARE Act do? So again, speaking to that issue of access, the CARE Act is essentially another pathway for eligible individuals with untreated schizophrenia spectrum or other psychotic disorders to be able to access mental health services, substance use disorder treatment services, and other housing or community support services. So this second bullet is the pathway simplified. It's really about starting with a petitioner who requests treatment for the individual, and from there, the assessment and engagement, court process, possible service connection follows. So that's the simple overview of the what, but let's move to the next slide and give you a visual of a little more detailed what of the CARE Act and the different pathways that one might follow. Really a visual that will guide our training today. So this is a visual that actually LA County created and has allowed us to share with you that provides a nice overview, not a complete overview, but a nice general overview of the CARE Act flow. Beginning with the initiation of a case with the petitioner and the assessment and engagement that follows with county behavioral health, moving to the court process in connection with services. And from there, for those who've engaged in a care agreement or a care plan, there's ongoing service delivery, the court process. And from there, moving to potential graduation from CARE Act. Or as we're putting it here, assessing for next steps. So, as complex as this appears on this one slide showing this court flow, it really doesn't represent the entire process. In fact, LA County has multiple slides to ensure that the entire process was reflected, but we really wanted to share this first snapshot that they gave us that gives us more of a general overview. And we also wanted to call out the fact that although there are potential dismissals throughout the CARE Act court process, the only one that's reflected here is in that engagement phase, because we wanted to highlight that why again, that access to treatment. And one of the primary hopes behind the CARE Act is to prompt that engagement in care and services that are voluntary, and essentially divert someone from needing to engage in the CARE Act court process. It's definitely another option for folks and another access point to treatment. So again, today, if you look at that top bar, we've color coded. We've color coded the flow for you as we walk through the process. Starting with the blue, case initiation and engagement, moving to the red, court process and service connection, and ending with that final phase in yellow, service delivery and assessing for next steps. So let's go to the next slide. We also wanted to highlight some additional pathways for individuals to potentially access CARE Act court process, including services and supports, and really there's three. So there's three courts that can make referrals to CARE Act. There's the assisted outpatient treatment or AOT court for individuals who are already a part of an outpatient court order treatment plan or somewhere in the AOT process. And in that case, the AOT court can refer these individuals for CARE Act. However, we wanted to call out that there still needs to be a petitioner. It's not a straight referral into the care court process. So for AOT, it would be the county behavioral health director or designee to petition. The other court is the criminal court, and these are individuals that are misdemeanants who are found incompetent to stand trial or IST. And really, the statute doesn't specify specific petitioners, only eligible petitioners that we'll be talking about shortly when we get into the roles. And then there's the LPS court or Lanterman Petra Short Act court. These are individuals that are already in conservatorship. And in this case, the conservator is the petitioner. Let's go to the next slide and move into the roles. So today we're going to cover the court flow, and we're going to tie that in with a scenario about a client that is participating in the CARE Act and the different paths that this individual may take in the process. But we're going to start with an overview of the primary roles within the CARE Act. Let's go to the next slide. We're going to call out 6 roles today. The client also is known as the respondent, the petitioner, the volunteer supporter, the county behavioral health agency, the housing and community support providers, and of course, the care court and the roles within that court. So let's start with the client, who also may be called the respondent once they're in the care court process. This slide gives a summary of the eligibility criteria for individuals who may access the CARE Act process. So these individuals who are 18 or over, these are individuals who have a diagnosis that is on the schizophrenia spectrum or have another psychotic disorder that we're not spelling out here, But of course, we do have a link that's more specifically calls out the eligible diagnoses. And we'll actually be covering these categories of mental illness in a future training as it relates to eligibility for the CARE Act. So more to come there. So again, just touching on who may be eligible. Who is this client? Who is this respondent? So these individuals that with these diagnoses are exhibiting symptoms that are severe and persistent enough that these symptoms are interfering with their basic activities in daily life and their functioning. These are individuals who aren't stabilized in treatment. They're likely not in treatment and really are thought of as either not likely to live safely or independently in their current environment, and they're declining with their condition, or with the right services and supports in place, any further decline in their condition could be prevented. These are individuals who are identified for CARE Act because it's the least restrictive alternative to other avenues, such as the LPS process or incarceration. And these are also folks that are identified that they may benefit from participating in the CARE Act process that can connect with them for them additional treatment services and supports. So here on the right, you see that little cartoon of Michael as our case example. And for today's purpose, we'll be talking about Michael as our client or respondent when we walk through the court process. We'll also be talking about the family, the behavioral health provider, and the other roles that he intersects with as he navigates through the care court process. Let's go to the next slide. So moving on to the role of the petitioner. So we think that there's a lot of interest in who actually could be a petitioner. This list here is essentially noting that, what are anticipated to be common petitioners for the CARE Act, but it's not a comprehensive list. We do have a comprehensive list in that link below from JCC's CARE Act eligibility fact sheet, but but let's review this list. So essentially the petitioner could be a family member, but it's truly limited to certain family members listed here. A petitioner could be a mental health professional or a service provider who is currently treating or has recently been treating the client. Petitioner could be the director of a hospital or designee in which the person was recently or is currently hospitalized. So again, another pathway into care could be from hospitalization. And then we have the directors of different public service agencies, and a big group is going to be behavioral health. So the county BH agency, APS, or Adult Protective Services. And of course, as we've mentioned, the petitioner could be a guardian or a conservator. Another group of petitioners could be a first responder, someone who has done outreach, such as police, someone who is part of a crisis mobile response team, who has repeated contact with the client. Homeless outreach workers also qualify as petitioners. And then interestingly, someone who lives with the client, who's not related to the individual, can be a petitioner. And finally, the client themselves can petition. We want to call that out again, knowing that the CARE Act comes with access to care, access to supports, potential housing. Individuals may want to self-select to be a part of this process, and they certainly can. Let's go to the next slide. So let's talk briefly about the role of the volunteer supporter. I want to call out that there's a lot of questions regarding this role. And in fact, we will be providing training and technical assistance, or TA, related to really the scope of this role. So more to come on the volunteer supporter role. But what we do know about this individual, and I'll essentially start from the bottom of the slide, calling out the fact that this is a person who is ideally identified by the client or respondent, but most importantly is approved by the client or respondent. And essentially the role of the volunteer supporter is an individual, again, working up from the bottom of the slide, who not only respects the client's preferences and goals, their values and beliefs, but essentially advocates on their behalf for these things. So this is a person that supports the individual to speak for themselves in terms of their own preferences, with the ultimate goal of supporting that individual's independence and autonomy and ultimate decision-making authority over their own life. This person may be a part of the care agreement or the care plan to support the follow-through and access to these additional services. So again, there's more to come on the volunteer supporter role and who might be playing that role. But again, the messaging here is that this is an individual that is approved and ideally identified by the client, is supporting them in their own independent decision-making and supporting them in communicating their own preferences, needs, and goals for the care plan. Next slide. All right, so we've got the other important role here, which is the County Behavioral Health Agency. And this is really referring to the agency that is ultimately assigned to engage with the client as they enter into those different pathways of a care agreement or a care plan. And thinking about the CARE Act population, the County Behavioral Health Agency will likely engage either their assertive community treatment teams or ACT teams or other similar models or approaches. Many counties have the full service partnership teams or FSP teams that are very ACT-like in terms of being outreach focused and really a wraparound model. In short, the county behavioral health agencies and their teams will look different across cohort 1 counties, but they are a key player in providing that outreach, that initial report, that clinical evaluation, and essentially on point for engaging in not just the mental health treatment, but connecting that individual with those other services and supports such as housing. So very much a key player in the CARE Act process. Let's go to the next slide. And then I'll speak to another key player in the CARE Act, and that's housing. And not just housing, but community supports are also called out to be prioritized for individuals in the CARE Act. So this is just a snapshot of the different potential types of housing that the CARE Act client or respondent may have access to, calling out the different supportive housing models, permanent supportive housing, interim housing models, or bridge housing models, really the array of necessary affordable housing models, and really unique to each county, different community-based housing models. But if you look at the Welfare and Institutions Code, or WIC, section 5982, there are a multitude of housing programs, funding sources, housing models, and other community services that are highlighted as priorities for access for this population. The other call out in 5982 that you might already have heard about is that these individuals should be prioritized for any appropriate bridge housing that's funded through the BH Bridge Housing Program. So there's more to come on the role and scope of the housing and community supports providers within the CARE Act. And honestly, the one thing we want to highlight here is that it will look different for every county, depending on what type of housing works, not only for this population, but for each specific county. Let's go to the next slide. And now, last but not least, let's talk about the CARE Court roles. And this is where I will hand the mic to Anne to speak to the different roles within the court that support and manage the CARE Act process.
Thank you, Laura. Yes, so this is a court process, and as such has an array of court roles. The behavioral health entity will have their counsel. That's usually going to be county counsel or another designated attorney or entity. And the respondent will have counsel. So Michael will have counsel. The statute lays out that respondents have the right to court-appointed counsel regardless of their ability to pay. It also lays out a process by which that can be either a legal aid organization, a qualified legal services provider, or if none is willing to take the appointment, the public defender, or an entity similar to a public defender. And that attorney's role is there to represent the respondent. They have all of the duties and requirements under a professional code to represent the respondent in their interests and to protect their due process rights. And then last but not least, there is a judge or judicial officer. And the judge's role is to be a neutral arbiter. They are looking at both sides, reviewing the evidence that comes in. But the statute does specifically lay out that unless there is a dispute of fact or law, they will endeavor to make it as informal and non-adversarial as possible. However, if there is a dispute, then it may become more like a traditional adversarial process. And lastly, one note I want to make is that the respondent does have the ability to hire their own attorney if they are able. And we'll talk about it when we get into the hearings, but they can substitute that attorney in at the initial appearance. And those are the care court roles. So I'm going to turn it back to Laura.
Thanks, Anne. So yes, we're going to move on to really the journey through CARE Act, but just take a moment to think about the roles that we covered today and areas that you may have additional questions or needs for clarification. But from here, I'm going to hand the floor to Carol to walk us through that journey through the CARE Act. Carol?
Okay, thank you, Laura. So let's go to the next slide. What we're going to talk about now is an overview of each of the stages of the CARE Act. So the first stage is called it's called the initiation and engagement stage, but actually the engagement happens throughout the process. And that's something that is really important to keep in mind because the engagement with the client is what is going to get the client to be interested in the CARE Act process, to be interested and engaged in all of the services that can be provided for them. So we will start out though talking about this initiation stage and what happens when somebody first goes to court. We will then be looking at the steps in the court process to getting to the care plan or the care agreement. And then we'll talk about next steps, which would be 1 year after involvement. We are going to be focusing in this webinar on the first two stages on initiation and engagement. We'll be going over next steps, but we'll talk about them in more detail in our next webinar. Next slide, please. This first stage, first section, so this includes the initial petition and review by the court, and then looks at what is the county's responsibility at this point. Next slide. In order to go through all of these steps, we thought that it would be helpful to talk about one specific person, one specific case. So we would like you to meet Michael. Michael is not an actual person. Michael is a conglomeration of cases that many of us have worked with throughout our career. So what is Michael's background? Well, Michael is 43 years old. He was diagnosed with schizoaffective disorder at the age of 18. Soon after the diagnosis, he dropped out of school. He worked at a few odd jobs while he was living at home, but eventually he left home. He became homeless. He did, in his younger years, he had a close relationship with his parents, but as his illness became more severe, he became less trusting of his parents. His parents are Brian and Sarah. He spent several years in various homeless encampments, but he does stay in the general area where he grew up. So his parents have been trying to keep track of him the best that they can. He has declined to move back home or move into any other kind of stable housing. He was hospitalized several times in his life, but was usually discharged pretty quickly. He would take medication while he was there, and then once he left the hospital, he wouldn't take medication anymore. So how is Michael's current functioning? So currently, he often appears internally preoccupied, as if he's hearing voices. He has been losing weight and sleeping throughout the day. It's not to the point where it's a medical emergency, but something that people who know him have noticed, that there's a change in his functioning right now. There were several times in his life where his behavior was so erratic, he was placed on a welfare and institution 5150 hold for grave disability. However, he is, as I said before, he's seldom in the hospital beyond those 72 hours. He goes to a local soup kitchen every day for a meal, and he has a sleeping bag that he sleeps in at night. His parents have sometimes gone to the encampment to try to persuade him to move out of the encampment. They fear for his safety. He is becoming more paranoid. He's been yelling at people in the encampment. And as a result, there have been a few assaults on him from others who are in the encampment. He also, when he goes to the soup kitchen, will sometimes yell at the staff there because he is beginning to get concerned that they are wanting to harm him. However, they will then call the police, and Michael will leave before the police arrive. He will then go back the next day. He's been misusing methamphetamines for the past few years, which have exacerbated his psychotic symptoms. And his parents have both contacted the homeless outreach team who work with people in the encampment, and they have not been able to engage him in spite of their outreach. Next slide. So at this point, what are the options that Brian and Sarah have? Well, there's AOT services, but he doesn't qualify for them because although he's been hospitalized, he has not been hospitalized in the past 3 years. He acts in a way that's intimidating, so he yells at people, but he has never been violent. So he doesn't qualify there. He doesn't qualify for a 5150 or an LPS conservatorship because he's not gravely disabled. So remember, people are saying, gee, he's looking thinner, but he is showing up at the soup kitchen daily to get something to eat, probably not eating as much. He does have a sleeping bag that he sleeps in. He's not a danger to himself, and he is not a danger to others, and he has never been suicidal. He does not express any intent to hurt other people. So he doesn't qualify for a 5150 or for a conservatorship. The last approach, which this is all that has been left, is just to wait and see. He's marginally functioning, but he's getting worse. And therefore, all his parents really can do is to wait and see what happens. It is likely, they think, that his functioning will get worse so that he can be placed on a 5150, but that's all they have. Until now, we have the CARE Act now. So the CARE Act can be initiated to help connect Michael with services and support. And so that the goal is that this is upstream so that there's not further deterioration, that family members and support people do not have to wait for their loved one to get so low functioning that they can be forced into treatment. Next slide, please. So Brian and Sarah eventually learn about the CARE Act, decide they want to take action on this and put in a petition. Their first concern is, gee, we're in our 70s, we're on a fixed income. How can we pay an attorney to file a petition? They learn that actually they don't have to pay an attorney, that family members are able to petition the court themselves. And so they visit the county court self-help center in order to develop and complete the petition. This petition also could have been filed by by other people, could have been the first responder who has had repeated contact with the respondent, the director of behavioral health, public guardian, our roommate, the respondent, mental health professionals, but in this case, it is the parents who provide it. Next slide, please. So Brian and Sarah go to the self-help center. Every county has access to a court self-help center, county court self-help center. The centers are provide free guidance. So they explained to Brian and Sarah what their options are. They helped them with the forms they needed to fill out, on how to file a petition. They explained what the next steps would be. They also explained what they could not do. So there are limits to what they can do. They could not give them legal advice. They couldn't represent them in court. There was no attorney-client privilege. And it's just important to note that all counties have a court self-help center, but not all self-help centers provide the same level of service. And so it's important to find out in your own county, what are the services that they can provide. Next slide, please. So this is just a quick self-check to test your own knowledge. So in Michael's situation, who can petition? Can Michael's cousin, who lives in a neighboring state but is supportive of the parent petition? And the answer there is no. Out-of-state relatives can petition, but cousins do not qualify. The police officer who repeatedly responds to the soup kitchen when Michael becomes disruptive, the answer there is yes. First responders who are familiar with the client can petition. What about a volunteer at the soup kitchen? And the answer there is no, a volunteer does not fit within the eligible petitioner criteria. And then the last one, a case manager from that homeless outreach team. And the answer there is yes, a case manager can be a petitioner within the first responder category. Next slide, please. Okay, and then does Michael meet criteria? So we're going to go through this quickly. Is his diagnosis a qualifying diagnosis in the schizophrenia spectrum and other psychotic disorder class? And the answer there is yes, because he has schizoaffective disorder. Does he appear likely to be at risk for not surviving safely in the community? And the answer is yes, because he has been assaulted. Is his condition deteriorating? And yes, we've talked about that, getting thinner, losing weight, sleeping more. Would this be the least restrictive alternative for him? And the answer is yes, because it's outpatient, it's less restrictive alternative than a 5150. Last one, he's been misusing methamphetamines and substance use disorder does not qualify a person for care. Why would he qualify? And the answer is his primary diagnosis is schizoaffective disorder. Okay, now we are going to go to the next steps after the petition. So once the petition is filed, the court decides if the petitioner, which in this case is Brian and Sarah, if they've made a prima facie showing that Michael meets criteria, and they are able to demonstrate that. And then at this time, a county behavioral health provider, rather than the parents, become the petitioner. So a county agency will determine whether Michael meets criteria for CARE Act and file a report in the court within 14 days, which includes the determination that he does meet criteria, the outcome of efforts made to voluntarily engage him, and conclusions and recommendations about his ability to voluntarily engage in services. Next slide, please. So during the 14-day period, the evaluator from the county agency assesses Michael for eligibility. Brian and Sarah would be able to get an extension on this 14-day period because it's in the best interest of everybody for Michael to engage. And the evaluator will attempt to engage Michael voluntarily. If he does engage voluntarily and agrees to services, then the petition is dismissed and there will not be any court proceedings. If he is found to be ineligible for another reason, like he does not actually have that disorder, if he doesn't have schizoaffective disorder, then the petition will also be dismissed. Next slide. And now I'm going to hand this over to Anne, who is going to talk about the court process and service connection. Next slide.
Thank you, Kara.
Sure.
So the first time when Michael and Brian and Sarah would potentially go to court would be for the initial appearance. So as Carol was laying out, a county agency has provided a report. It's been reviewed by the court, and they found that need to go ahead with the court appearances. The first is the initial appearance. And this happens within 14 days. And at this time, County Behavioral Health will replace Brian and Sarah as the petitioner. So for all other requirements of the petitioner going forward, that'll now be the County Behavioral Health Agency. However, Brian and Sarah will get to have some rights and the ability to make a statement. Brian and Sarah and County Behavioral Health must be present. If Brian and Sarah do not attend, the case may be dismissed. Michael can be present. However, he is allowed to waive his appearance through his counsel, which has been appointed and will be there on his behalf. However, if Michael does not attend and does not waive his presence, the court will determine two things. One, have there been reasonable attempts to get Michael to attend? And two, if it would be in Michael's best interest to move forward in his absence. If the answer to both of those questions is yes, then the case will go forward. At this point, the court may also appoint a supporter. For this example, we're going to use Sarah. So Sarah could be appointed at the initial appearance. And then lastly, the hearing on the merits will be set within 10 days. If the parties agree, they can stipulate to have the, which means agree to go forward, have an initial appearance at the same time as the hearing on the merits. However, in this case, Michael wants to contest the petition, and so they don't stipulate to it and we move forward. Next slide. So as mentioned, at the initial appearance, a volunteer supporter may be appointed. Sarah, in our example, requests to be that supporter, and initially Michael agrees to that. So how does that work going forward? So he has this, now she can be there as his supporter and attend meetings and hearings with him. However, as it goes along, they realize that they have very different goals. His mother wants him to move back home. He doesn't agree with that. And so they decide that this could be problematic. If there is a conflict between the supporter and the respondent, who in this case is Michael, the court may remove the supporter. And if it can't be resolved in a way that might not possibly hurt Michael, then the court must remove the supporter. So in our example, Sarah will be removed as his supporter, and the court may substitute in another person, but only if Michael agrees to that. Otherwise, he can go forward without a supporter. So now next slide, please. All right, so the next hearing would be the hearing on the merits. The hearing on the merits is essentially the first time that the court will really be making a determination about Michael's eligibility for CARE Act. When reviewing the initial petition, the court is looking at it at a much lower standard. However, at the hearing on the merits, it is a clear and convincing evidence standard, so a much higher standard. So County Behavioral Health and Michael, through his attorney, will be able to provide evidence, witnesses. Brian and Sarah do have the right to make a statement at the hearing on the merits. And after it all, the court will determine if there is clear and convincing evidence that Michael meets the standard for CARE Act. Here we will find that he did. So the court will order Michael, his attorney, if he has a new volunteer supporter, and the behavioral health agency to attempt to develop a care agreement. And that will be the next step in the case. So next slide. So the parties will attempt to create a care agreement. So a care agreement, as we talked about before, is a voluntary settlement agreement by which lays out the services and supports that Michael would receive. And if he is willing to accept that, if they can come to an agreement, they will come to the case management hearing with that information. And so what happens at this next stage, which is generally within 14 days, although it can be expanded if more time is needed, but the court will look to see if the parties have been able to reach an agreement or if they're likely to be able to do so. And if they are able to reach an agreement, the court will approve those terms and potentially modify them and set a progress hearing for 60 days out. On the other hand, if the parties have not been able to reach an agreement, the court will order County Behavioral Health through a licensed behavioral health professional to conduct a clinical evaluation and set a clinical evaluation hearing, which will be the next step. And we will cover on the next slide. Great. So within 21 days of the case management hearing, there will be a clinical evaluation hearing. Now this County Behavioral Health will submit a clinical evaluation report, including an array of information such as eligibility for the criteria, capacity to give informed consent, recommended services. And again, the court will look from a clear and convincing evidence standard to determine if Michael still meets the criteria. So because this may be Michael's first court-ordered clinical evaluation, so there may be new evidence. If there has been an evaluation within the last 30 days, they can agree to use that. So then what happens at this hearing? Said the parties can both provide information. If the court finds that Michael continues to meet criteria by a clear and convincing evidence standard, it will order the parties to attempt to create a care plan. If it does not find that he meets that criteria, perhaps he's stabilized some or he's now getting voluntary treatment, the court will dismiss the case. So in our example, the court does find that Michael still meets eligibility. And so the court orders Michael and County Behavioral Health to work on creating a care plan. And that plan, which we're going to talk about more on the next slide and in future trainings, can include things such as medication management, working with the housing navigator, working with a social worker to apply for benefits, and a variety of different pieces. Next slide, please. And I'm going to send it back to Carol to talk about the components of Michael's care plan in our example.
Okay, thanks, Ann. So this is an example of a care plan that could be developed for Michael. So after evaluation and discussion with Michael, his attorney and his volunteer supporter, this would be what is included in Michael's care plan. So one thing is behavioral health treatment. So he will be ordered to attend weekly individual and or group counseling. Medication management, he must see a psychiatrist and work on a plan for stabilization, which could include psychiatric medication, depending on his evaluation with the psychiatrist. He's going to be working with a housing navigator on a plan for housing, and he'll work with a social worker to apply for Medi-Cal benefits and to discuss what services are available to him through those benefits. Next slide, please. So in this scenario, Michael does go to his court hearings. He does work with his attorney, but he ends up just not really agreeing with most elements of this care plan. However, the clinical evaluation says that he does meet the eligibility requirements. Engagement in this process is incredibly important. So you have here, he obviously needs the help. He's been evaluated and found to be appropriate for needing this level of help, but he's saying no. So think about how important it would be to engage with him and what strategies can be used. Next slide, please. Remember that this is a court-ordered plan, but also that there are limits on what will happen if he doesn't want to participate. So it's not like he's going to be referred to probation or something like that if he doesn't participate. So what that means is the role of that support person and other professionals working with him are really important when there's not initial agreement, because engagement is so important. And so to think about what is that going to require? Well, one thing, and I mean, Laura mentioned this for the support person, it's very important for this person to understand and respect his autonomy, his right to self-determination. I mean, you're working with somebody who obviously needs services. However, he's not at a point where anybody is going to force those services on him. So how do you work with somebody like that who has ideas about what he wants his life to look like? And it, you know, in this case, he's just not healthy. You would have to have the ability to encourage him to engage in treatment so that he can have a better ability to maintain his autonomy. And so this is a complex process. The training is going to be really important. It's important that you have training in mental illness, that there's really a good understanding of Michael's disorder and of what the treatment options are for his disorder. Training in trauma-informed care is very important, especially when you're looking at really respecting somebody's autonomy, respecting their self-determination, developing a collaborative relationship with them. Motivational interviewing techniques also very important in this process. Next slide, please. Okay, so what happens next is the County Behavioral Health and Michael together or separately propose this care plan to the court. The court will consider the plan and they will adopt the elements that support Michael's recovery and stability. If they find that he lacks capacity to provide informed consent, the care plan can include medically necessary stabilization medication. However, this cannot be forced on him. This is something that can be offered, but cannot be forcibly administered. Goes back to, again, the importance of really being able to engage him, because it's not like there's any penalty if he does not take it. Once the care plan is ordered, there will be status review hearings. The status review hearings will take place no less often than every 60 days. At the status review hearings, the behavioral health providers and the attorney can provide information on how Michael's doing, but also Michael can ask the court to enforce this. So Michael can go and say, I was supposed to get behavioral health treatment, but I haven't been able to get in to see anybody. So, so it really can be a very empowering process also for the client. Next slide, please. So the next steps, and again, we're going through this quickly because we'll be talking about it in more detail, but we do want to talk about the graduation process and the options there. Next slide, please. So there's a 1-year status review, and there are 3 options. There's the first potential outcome is that Michael elects graduation. So this means that he's doing well. He'll work with the county behavioral health department to develop a graduation plan. The graduation plan would include what are the services that he will continue to engage in. So that would be one. Another option is that Michael will voluntarily elect to stay in care. The court can permit Michael's extension for up to 1 year. And there are some good reasons to want to extend it if he feels like he's still needing services. He can have better access to services. Also, that accountability and structure could be helpful for him. The third is that the court will involuntarily continue Michael in care. And this would happen if, say, Michael just started to engage in services towards the end of that year. So he seems like he's doing well, but has not he's not done enough because he only started a few months ago. So they can go ahead and extend it, but that extension can only happen for 1 year. Next slide, please. So what happens if Michael decides he's not going to participate anyway? So one thing that can happen is the court can just terminate his participation in the care process. If they terminate the county behavioral health and the community support person, they can continue to provide outreach. It just won't be through the court. If eligible, the petitioner can refer him for the LPS route. So initially for a 5150 and then an LPS conservatorship, only if he meets that threshold. So if by the time you get to this stage, Michael is really having a hard time, they're really concerned about his health, he's not eating and sleeping all the time and putting himself in danger, because of his symptoms, they can at that point refer him for a 5150. If that happens if there's an LPS conservatorship hearing in the next 6 months, then they can use this information that there was a care plan and that he did not complete the plan during that hearing as information during that hearing. Next slide, please. Okay, so now if you would just like to reflect on the different phases that we have gone over today and to think about what are the questions that you still have about this phase, because we are really working on putting together trainings that are going to be helpful for everyone. So the 3 stages again: initiation, engagement, court process, and service connection, and then the next steps around graduation. So I'm going to now hand this over to Patricia.
Thank you so much, Carol, Ann, and Laura. Hopefully you feel more oriented on the roles in the process of the journey through the CARE Act. And on this next slide, we'll go over some next steps. So there are a few ways you could contact us. That email address, info@CareAct. Send any clarifications, questions, technical assistance requests. Also make sure you're signed up for notifications for trainings, TA, and other engagement by completing the form, and you can find that linked in the PDF. Also, we have a technical assistance request form that you could also submit through, or a feedback form. And then also we'll be adding more and more resources to that CARE Act Resource Center website. So continue to check back there, but please contact us and let us know what your questions are. On the next slide, it just features again that email address and our website. And then make sure on this next slide, you'll see some resources that are linked in the PDF. These are some of the resources we pulled from and we thought would be helpful. So thank you for joining this training, and please reach out with any questions or concerns.